So welcome everyone to Family Property Techy Tuesday. I know a number of our Family Property subscribers are familiar with these webinars, but it's an opportunity today to discuss the exciting family court merger that commences on the 1st of September, and also to highlight how your family law practice or mediation practice can be prepared for those changes and maximise efficiencies. So just a few housekeeping. We are live both on Zoom and the Family Property Facebook page. We are recording this session, and if you can add into the chat where you're from, whether you're a family lawyer, family mediator, etc. And then we do have Q&A that we'll be trying to answer live, or some written feedback. Just so that you know, we're not representatives from the court. We don't have all the answers. This is more of a discussion, but we have taken time to really look at the media releases that have come over the last month, attend some webinars about the family court merger, and look at the new central practice directions. So hopefully we'll give you some insights as to the changes, and also how family property can assist with the changes. I will also do some polls today. Hopefully this works. So I'll just launch the first one. Does everyone see that one? Yeah. So the question is, prior to this webinar, how prepared are you feeling about the changes to the family law system? So completely unprepared, starting to understand the changes, or you feel on top of the changes? And the answers are coming in now, fast. Yeah, and we're thinking completely underprepared, or starting to understand the changes. So I'll end the poll now and get the answers there. So we had 45% completely unprepared, 54% starting to understand the changes, and 1% on top of the changes. So hopefully this webinar will be an opportunity to feel a bit more prepared. So we'll get into it now. So most of you may know me. I'm Fiona Kirkman, CEO and legal founder of Family Property. So I help bring that legal foundation to the product. I'm also principal of Kirkman Family Law, which is a family mediation and collaborative practice that focuses on resolution without court. I am an accredited specialist in family law, mediator, FDRP, and lecturer. And my vision is to empower separated families to resolve disputes more efficiently and amicably through family dispute resolution, but also utilising legal technology. Tim, I think you've met my co-founder and Techy husband, but Tim, did you want to introduce yourself briefly?
Sure. Yeah, thanks everyone for joining. I'm Tim Kirkman. I'm the CTO and the technical co-founder of Family Property. So yeah, I really sit across the products and are involved in training and support, and everything that goes with running a legal tech product.
And last but definitely not least, we have a new member of Family Property, Therese. Would you like to introduce yourself, Therese?
Hi, everybody. Thanks for joining. My name's Teresa Ryan. I am the product owner and product manager of Family Property. For the last 10 years, I was also a family lawyer, primarily representing children. And I also am an accredited specialist in family law, and I've completed my master's in family law.
Excellent. So I'll just go into the agenda now. So what we want to cover off today is have a bit of a discussion around, obviously, the family court merger. So if you can add any questions into ideally the Q&A. We have got quite a few people attending the webinar today, so that will help us monitor the questions. We'll try and answer some as we go at the end of each slide, but at the end we'll also have an opportunity for Q&A. So what we want to do is go through an overview of the objectives and purpose of family court merger, we want to go through the core principles, the 10 core principles that were actually released in January 2020, just pre-COVID, and discuss the relevance of those to the family court merger, the central practice direction that we've been busily trying to get on top of when it was released on Friday, which will be a mandatory document that family law professionals will need to give their clients, as well as the new case management pathway, the steps involved in pre-action procedures, the first steps, the first court event and the dispute resolution phase, and then the trial phase. So we'll look at that case management pathway and then dispute resolution. Dispute resolution is being given a significant focus with the new family court merger, both internal dispute resolution and external dispute resolution in both parenting and financial matters. And there's really an expectation that where it is safe to do so, and obviously risk is very important, parties will avail themselves of every opportunity to participate in family dispute resolution, whether that's privately funded dispute resolution or court-based family dispute resolution. And I know we've got a number of family mediators on this webinar, and I myself am very excited and pleased to hear that there's a significant emphasis on providing dispute resolution opportunities. And lastly, as I said, a bit of a Q&A at the end, and some tips on next steps that you may wish to take. So we'll get into it now, and I'll be monitoring the chat, but I might head over to Therese to share on the overarching purpose of the family practice and procedure.
Thank you very much, Fiona. So the two divisions of the new court are going to be supported by a single point of entry, a single set of rules and forms. The rules have recently been approved, a consistent case management pathway, and 14 practice directions. So the most recent that was released is the contravention practice direction, which was released on the 18th of August. The case management pathway and the practice directions are informed by Section 67 of the new Act, and this sets out the overarching purposes of this new Act. It's to use court resources efficiently to assist parties and their families to resolve their family law cases efficiently and effectively. The court's aim is to minimise impact on litigation and reduce unnecessary cost. And this is regardless of the complexity of the issues in dispute, or the issues in dispute, and only subject to ensuring the safety of the parties and the children. So this means that the new rules and directions must be applied in a way that prioritises the best interests of children. Section 68, thanks, Fiona. This sets out the obligations of parties to comply with these overarching purposes, and also for legal representatives to provide estimates of the likely duration of proceedings, costs that they're likely to charge, and what costs might be payable if their client isn't successful. So in the central practice direction, there are also obligations that lawyers must keep the court updated in relation to costs.
So just to summarise that, Therese, it's exciting, single point of entry. I think the court has been trying to achieve that for a long time. Can you just explain the difference between Division 1 and Division 2?
Absolutely. So Division 1 will be what we now understand as the family court. So all current matters in the family court will be dealt with in Division 1, and all current matters in the Federal Circuit Court will be dealt with in Division 2. Okay. And just by way of example, the court is releasing 14 practice directions, including the central practice direction that we'll be looking at today. As an example, they've last week launched the National Contravention List, Family Law Practice Direction, and they're short practice directions designed to really explain what the National Contravention List is, filing in the National Contravention List, operation of the National Contravention List, etc. So there will be 14 different practice directions. They haven't yet been released, but stay tuned. I'm sure they'll be helpful for us in practice. And same with the rules. Therese, where are we at with the rules? Have they
been confirmed by the judges?
Yes, so the release on Friday confirmed that they had been approved, but I don't think that they've been released to the public as yet.
Yes, so we're eagerly awaiting the release of the rules, but it is under the Federal Circuit and Family Court of Australia Act 2021. All right, the core principles, Therese.
Thank you. So these principles were released in January this year by the court. We're not going to go through every single one of them, but I think in summary, they support early triage to identify and prioritise and also mitigate risks to children and parties. They support a consistent approach in the case management of a matter. They, as Fiona has already described, encourage the use of both internal and external dispute resolution processes unless it's safe to do so. It emphasises the importance of complying with orders, with practice directions, rules, and the possible consequences for non-compliance, which we'll get to go over it a bit later. And also proactively identifying the most significant issues in dispute and gathering the evidence as soon as possible so that practitioners and parties can be fully prepared for court events and hearings. Next one.
And that joint practice direction, as you said, was released in January 2020 and set out, again, the approach to case management, importance of ADR, identifying and narrowing the issues in dispute, etc. So the next approach to case management.
Thank you. So we've gone through what the different divisions are. In relation to appeals, there is a no appeals division. So all judges in Division 1 will be able to hear appeals either as a single judge or as part of a full court, and a Chief Justice will decide whether a full court is required in the circumstances. The other big change, I think, is in relation to registrar name changes. They've been changed to Judicial Registrar and Senior Judicial Registrar. In relation to the delegations to the Senior Judicial Registrar, a number of changes have already been made to their delegations. And whilst there are many, in summary, there are things like being able to hear undefended hearings and interim hearings in relation to specific issues such as parenting and spousal maintenance. So as we can see from this map, there's one single point of entry. So most cases will go through this consistent pathway. There are some exemptions. Urgent matters that are filed will go to a duty registrar for assessment. Matters that are allocated to a specialist list will have their own pathways, and those pathways will be set out in the special practice directions that are going to be coming. And then there are also going to be some individual cases that require a bit of a different pathway. There is a significant emphasis by the court on pre-action procedure, compliance, and dispute resolution. So if we look at this, this pathway, the first court event will occur within about 1 to 2 months of the date for filing. The main changes overall are that there's going to be early and ongoing triage and checking for compliance throughout this pathway. There's going to be a national assessment team who can review cases at any time. So they'll look at whether matters are suitable for a specialist list, what procedures may be required due to risk, and compliance with pre-action procedure. You can see that there is an interim hearing there in the middle. Now, this is not a given. Parties will need to show why an interim is required prior to a dispute resolution. Most cases will go to some form of dispute resolution within the first 5 months of filing. So that may be an internal or an external dispute resolution. Family reports, again, will not be a given. At the early stages, you can see in yellow that there's something called a child impact report. Now, this is an expanded 11F memo. It's one of the purposes is to get the voice of the child in an admissible form at the earliest opportunity. So that might be used for an FDR or for an interim hearing. In relation to reports, at the later stage, and if a dispute resolution, some form of dispute resolution wasn't successful or appropriate, the court might order a further report. And these types of reports are things like a family report, as they're currently prepared, a specific issues report. So this is whether there are only certain issues remaining that are outstanding. and a child impact addendum report. So this is an addendum to the child impact report, which will build on that report if necessary. All specialist lists will continue, and there will be a list for property only, and these will be separated into their own first return list. Okay, so when will a matter usually be transferred between the divisions? Usually at a first return date or at a compliance and readiness hearing. If the family court holds exclusive jurisdiction, say for example for a Hague matter, that will be transferred without you having to file an application to transfer. And the transfer, when they're considering whether or not this should be transferred, they will look at things like complexity, multiple parties, how many witnesses there are, the length of a matter, whether it raises a really important issue for family law jurisprudence, parenting cases where there's criminal conduct, or a financial case with significant complexity. Now, as we've spoken about before, there is a significant emphasis on compliance. So you'll see that there's different points at which compliance is checked. That is at the first court event, the compliance check, and the compliance and readiness hearing. And there are quite significant consequences to that. And they can include things like the court making a negative inference, setting aside a step taken or an order made, dismissing all or part of a party's application, determining an application on an undefended basis, adjourning to allow parties to file further evidence, or make orders as they deem appropriate, and that includes cost orders. If we look at the dates here in the bottom, what we'll see is that the court aims to finalise 90% of the matters within 12 months or have a matter listed for hearing within that time frame. In relation to the judgment will, the court will aim to provide that as soon as practical or within 3 months. Thanks, Fiona.
So just a couple of questions arising from that. So which cases go to Division 1 and which cases go to Division 2? As I understand, there's a central single point of entry filing in Division 2, but how would a matter, which matters would move and be transferred into Division 1 and why?
As I understand it, matters like, for example, Hague, as I've mentioned, Magellan matters, and other matters that are of significant complexity, such as property matters, and I think that's all the sorts of matters that might be transferred.
Yeah, and the Family Law Act, that's still applicable and relevant?
Yes, and I understand that there are proposed changes to the Family Law Act, but we haven't been advised of those yet.
Thank you. And this child impact report, that's who conducts that child impact report? Is that still the family consultant, or is somebody else doing the child impact reports?
They are still going to be undertaken by family consultants, but they have a new title, and that is Court Child Expert.
Great. Okay. Feel free to continue to add your questions in this case management pathway. We're going to go into some of the relevant steps like the pre-action procedures, first court event, and dispute resolution for parenting and financial during court proceedings. But feel free to ask any other questions about the case management pathway as we go through. So, in regards to pre-action procedures, as we know, Schedule 1 to the Family Law Rules, this is the current Family Law Rules, but this is still going to be applicable but extended. It's retained and enhanced, and it will apply across both divisions and will be enforced. As Therese said, compliance is going to be a big factor in the family court merger. So it's important to understand the Schedule 1 to the Family Law Rules, or the new Schedule 1, and make sure your clients are complying with that. before commencing court proceedings, it will really be important to make sure that the clients are complying with the pre-action requirements. I know they should have been to this point, but it will really, again, compliance will be really important moving forward. So questions around, have they participated in dispute resolution, which might be family dispute resolution, negotiation, conciliation, arbitration, or counselling under Section 60I and Schedule 1 of the Family Law Rules. Have they exchanged a notice of intention to make a claim and explore options for settlement via correspondence? Have they complied with the duty of disclosure? And have they made genuine attempts to settle the dispute? So before commencing proceedings, it's really important that those boxes have been ticked and the court will be checking that those pre-action procedures have been complied with. Also new to the new case management pathway and the new system, there's this central practice direction, 33 pages, which sets out the purposes, the application of the practice direction, which we need to, as family law professionals, give to our clients, the core principles, which Therese discussed, and case management. So, as we said, pre-action, requirements, filing, urgency, triage, and assessment, and then the relevant court events, the first court event, interim hearing, dispute resolution, and then the trial phase, and then the circuits and specialist lists. So we'll go through some of that today, but it's really important that that be given to your clients, and unless exceptions for genuine urgency or where it is not safe to undertake the pre-action steps, they must be complied with. So there's still those exceptions, urgency and safety issues, but otherwise pre-action procedures must be complied with, and you must provide a copy of the central practice direction that we should all become familiar with. There's a couple of questions here, and then Tim's going to do a short demo of how family property can assist with compliance of your obligations around gathering the right information and documents from your clients, making sure that you've given the central practice direction and information about costs at the earliest opportunity. And he'll be sharing his screen in a moment. But some questions that maybe Therese can assist with as well. Jessica asks, please clarify, if known, the criteria or process around whether matters are referred internally within the court for dispute resolution or externally to a private FDRP. Jessica, we might leave that. And in a moment, I'm going to be talking about that specifically and the difference between privately funded family dispute resolution and court-based dispute resolution. So I'll come back to that. And Fiona asked the question, will dispute resolution be mandatory for property-only matters? You will need to file a genuine steps certificate, but it's not necessarily just family dispute resolution. There are some options there, and I'll talk about those shortly in a moment. So Tim, I'll let you share your screen, if that's okay.
Fantastic. Sure. Just sharing my screen now. Can you all see that okay?
Yes.
Yeah, perfect. So we're just going to quickly go through how a tool like Family Property might help you with a few of these steps that we've just talked about. Right now, I'm just going to quickly focus on things like how to gather the right information, how to disclose costs and make people aware of their obligations, and also how to collect the right documents from your clients. So if you are familiar with Family Property, you're probably quite familiar with the experience around our intake questionnaire. But if you're not, this is what it looks like. Family Property comes with a really comprehensive intake questionnaire. I'm just slowly scrolling down so you can see the different categories of information that you can collect here, but it covers everything from your general style questions, which might be personal details about the relationship, when they began living together, separation, are they divorced, married, whether they've got children, the current living arrangements, and that's also for both of the parties, but also the children. And then we've got a whole section here. These steps here cover property specific information like income and expenses from your client. Assets and super is obviously a really important section that collects information around real estate, household contents, bank accounts, vehicles, investments, and every other kind of asset and super fund that is possible. It is designed to be completed for really simple asset pools really easily and quickly. You can just go down and leave everything on no, where it's not applicable. But where you do have a more complex asset pool, it can support that too, where you've got businesses, multiple businesses, trusts, shares, and things like that. So we've got 6 different sections here. What is owed is liabilities, contributions and future needs factors are obviously those really important, legal-based information that you'll need to collect around your clients and the other parties' contributions and future needs factors. If you do use family property, or if you're looking at it for the first time, I do want to just highlight 4 new sections that we have introduced here, which help you capture information around your client's current situation. So these are things like where you're or where they're at, whether they've obtained legal advice, whether they've already attempted a dispute resolution process, whether they've got advice from other professional practitioners, and so on. Proceedings and orders, family violence, how you're coping. These are really important sections to help you really get a full, complete picture of your client's situation. And finally, and also a fairly new section as well, is our parenting section. So parenting arrangements here allows you to capture information around each of the children in the relationship and the parenting arrangements and situation for each of the children. But once you have, or your client has completed the questionnaire, you click the submit button to complete the process. And that's what I'm going to do right now, and just bring up the new panel that we've got here. So just give me a moment. Fiona, do you want to make some comments on the on those new sections?
Yes. So in regards to risk, as we know, the core principle, the number one core principle, is assessing risk. And so you need to have, as family law professional, practices and procedures in place yourself to make sure that you're gathering the right information around family violence, capacity, issues such as alcohol and drug misuse, mental health issues, etc. And so family property assists with that. You can either ask your clients to complete that questionnaire. It is an optional questionnaire, so you can ask them to complete that, or you can gather that information from them in, say, an initial client conference, etc. But what we've aimed to do is give that flexibility and enable you to properly assess risk and have that information upfront as early as possible. Tim?
Yep, thanks for that. So when you do click on the submit button, for people that are familiar with family property, normally it gives you a really concise message asking you to confirm those information. What you can do now, though, is you can optionally add a few additional questions. So the first one here is, lastly, how did you hear about us? We have got a lot of requests around capturing that information. What was the referral source from your client? So you can optionally now add this particular question to the confirmation window. You'll also see here that you can also provide your own specific wording around terms and conditions. You can mention and discuss your cost agreement at this point. And if you do provide your own wording, your own custom wording here in family property, the person filling this in will need to agree to the terms and above before they can click submit. And finally, another new option in the family property process is that you can optionally ask the person to consent to join your mailing list. Again, we have had a few people ask that they would like to continue the communication over other channels with their clients. And so now you can collect that consent from your clients too by ticking that box, and then clicking submit obviously then completes the intake process.
And somebody's asked, just for clarification, is it mandatory for a family lawyer to provide that central practice direction? Yes, it is, at the first available opportunity. And that's why we suggest maybe it might be good when completing the questionnaire to provide a link and ensure that they've the client to acknowledge receipt and having read that practice direction. There is also another question on when do we get the other practice directions? Yes, we're waiting for those other 13 practice directions, but we know that it will be on each discrete area, such as the National Contravention List. And this central practice is, I guess, the main practice direction that is mandatory to give to clients. It also is, as Claire comments, if somebody is self-represented on the other side, you're requested to give a copy of that central practice direction to the self-represented litigant. Tim, did you want to showcase the portal briefly and how that assists with disclosure?
Sure, yeah, absolutely. So I'll just start my screen share again so that you can see the process here in the portal. So one moment, there we go. Can you see my screen there okay? Great. So once you or your client has submitted the questionnaire, your client then has access to their own client portal in FamilyProperty here. And I'm just scrolling slowly down here. What you'll see is that this is designed to provide a really simple, structured way for your clients to understand the documents and the information that they need to provide to you as part of their duty of disclosure. And what FamilyProperty does is analyzes all the information that they've just filled in the questionnaire around their assets and super and liabilities and even contributions and future needs factors, as well as income, and lists each item on the screen. So here, for instance, 30 Barker Street, Sydney, New South Wales is the family home. And then it makes recommendations to your client around the kinds of documentation information that they need to provide to you. For instance, they need to go and get an appraisal, online valuation, or formal valuation done. And often council rates are also very important, as compared to shares in Telstra, where they should upload their investment documentation. And we can also give pointers and tips around how to go and get that information. Now, you can turn off these pointers and tips if you would prefer to do these yourself, but you can include them in FamilyProperty as you like. So I'm just slowly scrolling down here just to give you an idea of the kinds of recommendations that will appear. They're each tailored for the different type of asset, liability, and super fund that the person has. And once they've got that documentation together, they just click attachments, and then they can click select a file to attach. And then it's really easy to then get the document up into the portal by simply selecting the file and then clicking attach, and that's it. They can upload a bunch of documents or one document at a time. And as they work their way down the list, they can continue to tick off these tick boxes, effectively like their own homework checklist, so that they can keep track of their progress.
And just on that, right at the top, there is some information about the duty to provide full and frank disclosure. We're monitoring that at the moment. We link to the duty of disclosure brochure, but that may be updated, and we'll be updating it on the system. But this is something that can be tailored to your own family law practice or mediation firm. There's also talk of an undertaking as to disclosure once you get into the trial phase, and we may link to that as well. And the benefit of using this portal, it's tailored recommendations securely online, saying on the snail mail collection of documents, and we can they can easily drop valuations and various bank statements, etc., into the portal. And then if you go to actions, Tim, actions, they can download those as a zip file, automatically creates a document index, and then they can share those documents. So we do have, as part of FamilyProperty, which we won't showcase today, but we do have a full two-way disclosure portal where you can share those documents through a secure link with the other side solicitor. and the other side can, even if they don't have family property, they can upload documents back into the disclosure portal, all automatically listed into a document index, and also list when the documents were downloaded by the parties. So again, if we come back to case management and the importance of pre-action procedures, there's really a big focus on the compliance with the duty of disclosure, getting the right information, and exploring options for settlement. And we believe family property can really assist with that. I'll just share my screen. I don't think there's any other specific questions. Actually, a question for Therese as I bring up the next slide. Is the National Contravention List a specialist list in Division 2 of the new merged court?
I'm actually not sure about that. I'll have to check the practice direction and I'll get back to you.
We'll have a look at that. So next slide, genuine steps certificate. So this is a new step involved when before commencing court proceedings, in addition to a Section 60I certificate. So as we know, if it's a parenting matter, there's a requirement to participate in family dispute resolution for parenting matters, unless an exception applies. But for both parenting and financial matters, there'll be an obligation on both the applicant and the respondent to an application for final orders to file a genuine steps certificate certifying that they have, 1, complied with the pre-action procedures, and 2, made a genuine attempt to resolve their dispute. And the basis of any claim for an exemption from compliance with either or both of these requirements. So compliance with pre-action procedures and genuine steps taken to resolve the dispute. The genuine steps certificate will be in an approved form. It has not been launched yet, so we can't unfortunately show that to you today, but I anticipate it may go along the lines of the proposed amendments to the Family Law Act that were considered by the Joint Select Committee on Australia's Family Law System, Appendix 4, which looked at genuine steps to resolve a dispute and examples of behaviour that may constitute steps taken, including notifying the other person, and attempting to negotiate with the other person, responding appropriately to any such notification, providing relevant information and documents to the other person to enable the other person to understand the issues and how the dispute might be resolved, considering whether the dispute could be resolved by a process facilitated by another person, including an alternative dispute resolution process. So, and then agreeing on that process and who's to facilitate it and attending it. So some people have asked, will it be mandatory like a Section 60I certificate? Do you have to go to family dispute resolution? The Chief Justice in the webinar said it doesn't necessarily have to be family dispute resolution. It's not equivalent to the Section 60I, but there are steps that you will need that they constitute making genuine steps to resolve the dispute. And family dispute resolution would of course be one of those. Then it talks about in here the steps involved and why no such steps were taken. So examples of exemptions like urgency, allocations of family violence, fraud, unduly prejudiced, serious disregard to obligations, time limitation is close to expiring. And then it talks about the genuine steps statement to be filed by the respondent. So as we know in Section 60I certificates, it's only the applicant files, but our understanding for genuine steps certificate is the respondent will need to confirm whether they agree genuine steps statement with the genuine steps statement filed by the applicant, and if they disagree, why the respondent disagrees. So we thought that was helpful, but that is what we anticipate. We're of course waiting for the approved form of the genuine step certificate, which might look similar to what's in the Federal Circuit Court, where the following steps have been taken to try to resolve the dispute, and then list the steps, or no steps have been taken. And that may be something that's signed by the party and or by their legal representative. But it's a wait and see game. I think there's a question in regards to that. So if you have any questions, let us know. But yes, there's a couple of questions here. Will dispute resolution be mandatory for property only matters? As I said, genuine steps certificate, but not, it doesn't necessarily have to be family dispute resolution, but that will be strongly encouraged as part of the pre-action procedures. Some other questions here, Therese. Are you required the central practice direction at an initial consult or once they have retained you as their lawyer? At the moment, I can answer that. In the practice direction, it says at the first available opportunity. So if, for example, you're using the family property questionnaire as part of the intake, would recommend that that's part of the intake questionnaire or at that initial consultation, like the marriage, families and separation brochure, however you're required to give that, the first available opportunity. One last question. For ongoing matters in the Federal Circuit Court and family law courts, do you have to continue from where you are up to with new procedures? So what about matters that are currently in the system, Therese? How are they going to be handled?
It's not clear from the directions what will happen, but what we have been told by the court is that the family court matters will go into Division 1 and the Federal Circuit Court matters will go into Division 2. And I assume that, I'm not sure how much they will be adopted along this pathway, but I assume that given they're saying that this is going to be the direction from here on out, there will be some conformity to this pathway.
Great, thank you. So we'll move on to filing and preparation. What do the new forms look like, Therese? What do we need to file? And what happens, what do we need to do prior to the first court event? Yes.
So the main changes to filing for parenting, along with a initiating application and a Section 60I certificate and a notice of risk, parties now must file a genuine step certificate and only file affidavits if there are interim issues sought. So we're really bringing that into line with the directions that the Family Court have now. In relation to property, along with an initiating application and a financial statement, again, they must file a genuine steps certificate and only file an affidavit if there are interim issues sought. If for both parenting and property, if you don't have a reasonable excuse for not complying with pre-action procedure, the application may be stayed or adjourned until you rectify that. In relation to the forms, let's open the application for contravention. While we're opening that, what we understand is that the form changes are minimal, and they'll include changes to references to legislation, names and terms. So this application for contravention, I mean, it's pretty snazzy looking. It's been updated a little bit, and you'll see if we keep scrolling that options like what the changes the courts have changed. And then there's also reference to the Federal Circuit and Family Court Australia rules. And there's been some colour added from the looks of it. It's obviously going to be, you're going to have quite a significant look at the different documents to see the what changes there are. But that looks quite similar, I would say, Fiona, to the previous forms.
Yes, and when His Honour discussed the forms, it was, as we understand, more to harmonise the forms so that it's part of the Federal Circuit Court and Family Court of Australia, to add in the new rules and to just confirm the instructions. So obviously the initiating application will refer to the requirement to file that genuine steps certificate, etc.
Thanks, Fiona. Okay, so prior to the first court event, parties will have to have filed and served all their documents, and each legal rep will have to file a notice setting out the genuine attempts to resolve the dispute, whether or not their client has is in receipt of legal aid, and if not, any particulars in relation to costs. Now, that seems to be in addition to the genuine attempt certificate. In matters where there's no financial statement has been filed, and where there is no agreement to fund an expert report or private dispute resolution privately between the parties, parties will have to file a signed statement regarding either their status in terms of having legal aid, or they'll have to set out their income and expenses, and other circumstances relevant to their ability to contribute to expert reports and a private dispute resolution. In relation to an application in a proceeding, so they've renamed the application in a case to an application in a proceeding. So for any non-lawyers out there, that's an application that's made during the course of a proceeding to seek to vary particular orders that are in place, or in relation to resolving particular issues during the court proceedings. There is going to be a maximum of 2 application in a proceedings unless parties have leave to file further. And this, of course, there is an exemption to this where there is high risk. And along with that application in a proceeding, parties can file 1 affidavit by them and 1 by witnesses where the evidence is relevant.
So just to summarise, Therese, for filing, it will be an initiating application, financial, if it's say a parenting and property, initiating application, financial statement, notice of risk, section 60I certificate, genuine step certificate, but an affidavit only where there's interim orders sought. The forms will be harmonised, but there's unlikely to be significant changes to the forms, like becoming smart forms, which we'd like them to be, I think. And prior to the first court date, you must file and serve all the documents. This notice around the genuine attempts and the costs. And then if it's, say, a parenting matter only, a signed statement as to their circumstances and ability to contribute to those expert reports. And this application in a proceeding, is that akin to the old application in the case?
Yes, that's what we understand.
Yeah, okay. And there's a question here around application for consent orders and the template for the terms of settlement. Is that the process there likely to change, or the form change?
We won't know, I think, until we see those forms. We understand that they're going to be released imminently, but we don't know when.
Yeah, but His Honour has said that there's likely to be some changes to harmonise them, but no significant changes to the substance of the forms. Will an application contravention need to be filed if the genuine steps certificate prerequisites not met, or will the matter progress to interim stages where orders are made to rectify initial failings to complete pre-action procedures? I think that might be in the contravention practice direction, but we may come back to you on that one, Avril. And while we're doing that, we might hand over to Tim. Tim's going to briefly showcase how Family Property can assist with preparing the relevant documents, court documents. In this instance, the initiating application, although we do populate the financial statement and the application for consent orders, and we are currently preparing the notice of risk to populate that as well. But today's focus will be on an initiating application seeking both parenting and property orders. Hand over to you, Tim.
Sure, thank you. Yeah, just going to share my screen again. Can you see that okay there?
Yes.
Yeah, fantastic. So now what I've done is progress this matter a little bit further in family property, and I'm now in what we call the dashboard, which brings all the information on the matter together into one screen. So whether you're working on your balance sheets or disclosure, parenting, whether you want to review current situation information and personal details that might have been captured in the questionnaire, or even consideration factors like your contributions and future needs, it's all here one kind of mouse click away, so to speak. But in order to kind of dive in and look at preparing these court forms, what I'm going to do is just show you how really quickly you can put together whether the parenting arrangements that you want to map into parenting orders, and also the financial agreement or orders that you might want to look at documenting into those various court forms. The great thing about something like family property, though, is you only need to put in this information once. And then all you need to do is just fill in a smart form then to complete those documents. So to give you an example of what we're talking about, I'm under the parenting tab here. And as you can see, we've got 2 children here. So we've got one aged 8 and one aged 11. And if I click on one of the children here, I can review the information that I've got about this child in family property. Now, if I head over to the parenting arrangements, you can see here that we've got a lot of information that you can then start to customize around the kinds of orders that you would like to automatically generate. And so, for instance, if I open up general schedule, we can see here in this particular instance, we're looking for alternating weekends where it's Alexander, so it's my client, has the has the children for alternating weekends. And in this case, the weekend starts on a Friday at 5 p.m. and ends on a Sunday at 5 p.m. And in terms of a fortnightly cycle, that's every second weekend. So that's what the general schedule looks like. And that also includes school terms for school-aged children. And if I have a look at what we've put in here for school holidays, this family here are going to share half the period, where Alexander's going to get the first half of each holiday period in 2021, and then they're going to alternate. So then Sophia would have the first half of all holiday periods in 2022, and back to Alexander, and so on. You can even put in handover times in these kind of scenarios as well to really fine-tune the orders that you're looking at generating. And then it's a matter of just going through the same kind of process for any other special periods. So there are things like Easter, Christmas, Father's Day, Mother's Day, birthdays. You can remove any of these that may not be relevant, and you can add your own custom periods as well. So family property is really flexible in terms of the important periods to each and every family. And so once you've just gone through and you've just put in the different parameters for the kind of orders that you want, that's all you really need to do. Then I'm just going to close this down to show you what happens. As you can see, what family property then does is then plots that in real time into a calendar. So you can actually see how that particular order that we're looking at, those orders there, or that arrangement then plays out over time. So I can see Alexander's going to have the children, and then back to Sophia, and then Alexander. And I can play that forward over month by month, seeing how it's going to play out over school terms and holiday periods, all the way through reality test Christmas. Yep, Sophia's going to have Christmas. And we've pre-populated this calendar across Australia with public school periods, both in holidays and school terms for the next 2 to 3 years. So you can really reality test these orders against the real calendar here and see how they play out over time. And yes, a common question we get asked is, can you print this, give it to your clients? Absolutely. You can generate this into a PDF and give that to your clients. So that's the first part that we wanted to show you, is how you can design your own parenting arrangements that you might want into parenting orders. And then if we head over to balance sheets to have a look at the other side, which is property, what we've got here is we've got our list of assets, liabilities, and super funds. Obviously, this has come across straight from the questionnaire that was completed. But if you want to add more, you can just click the add button and then fill in whether you want to populate another asset, liability, or super. So you can continue to keep this up to date at any point in time. Now, what you'll see here is that we've got, you want to obviously start with confirming identity, ownership, and value of each item. But when you're ready to kind of put together an agreement or a set of orders that you'd like to generate, you use what we call sliders here to just visually model what you want to do with each item. For instance, I can grab this and I can move this into Alexander's column, which means because the family home's in joint names, we want to transfer the ownership to Alexander, versus moving it to the right, we want to transfer the ownership to Sophia. And anywhere anywhere in between is a sale action. And it doesn't have to be 50-50, but if I leave it at 50-50, that means we're dividing the proceeds of sale 50-50. So as you can see here, I've just really quickly gone through and moved these sliders. It's only taken a few seconds. Alexander's going to keep his assets. Sophie's going to keep hers. We're going to discharge the mortgage. Alex is going to keep his credit card, and they're going to each retain their super funds. But Family Property can model a lot of various and complicated scenarios with super splits, two pool divisions and things like that as well. But just for simplicity's sake, I've just gone through and split those items that way, and we can see the outcome here of 51, 48, almost 49%. So now that we've put this information in, the great thing about Family Property is now I can generate and populate this information to a variety of different court forms, whether it's the financial statement or whether it's the initiating application or the response or a variety of other documents. All I need to do is model these orders or agreements on the screen once, and then I can populate all of this information time and time again into the court forms. So how you can do that is head over to Documents and go to Show All. This is our full library of documents that you can see here. The one that I'm interested in today is down in Court Documents here, which is the initiating application. So if I click on this, you'll see that a smart form pulls out here, and this is effectively the initiating application, but in a digital format, allowing you to fill in the blanks. So where you've already entered in information around the parties' names and addresses and the start of the relationship and end it, and all of that information, that will automatically go straight into the court form for you. But what you can do is you can use this smart form to confirm the information and populate all the other details that you may not have entered yet into Family Property that are required for the court form. And so as you can see here, I've said that I want to generate, please, some orders here for property and parenting. I want to pull it from the balance sheet and pull it from the parenting tab. And then if I click download, what that's going to do is it's going to compile all of that information into a Microsoft Word version of the court form. So I'm just waiting for that to download there. There we are. So being Microsoft Word, of course, you can then continue to work on this document. You can make changes, can send it to your client for review. But as you can see here, it's filled in all of the information that we've populated in the smart form there, ticking all the relevant boxes. And it's also generated the orders that you are seeking here. So the parties will do all acts and sign all documents necessary to sell 30 Barker Street. And you can see here that it's automatically generated the legal orders that match that agreement or the order that I wanted based on the balance sheet. And so you can see there it's got different orders for all of the items in the balance sheet, reflecting what I had there on the screen, including what will be retained by the individual parties, and then your catch-all clauses. And then down here, a little bit further, is your parenting. So what's going to happen in general living arrangements, and then your holiday periods and special occasions and changeover agreements and things like that. So you can see those legal orders have been put in there, and then it continues on with the rest of the court form, populating this from the information you see there on the screen. Fiona, do you want to add anything in relation to the information that goes in this court form, how it's compiled, or especially those legal orders?
So we'll be updating this initiating application as soon as we get our hands on the new form. But as you can see, the benefit of using Family Property, the new parenting product, is that you can visually map out on a calendar what the parenting arrangements look like. And then that automatically generates the parenting orders, which is just a template. So you can update the template of your parenting orders for the wording that you like. And the same for property. Our unique value proposition for Family Property is we've really gone deep on the property settlements and modelling and comparing different options for the property settlement using those sliders. And then once you have worked out the proposal that you're seeking or the orders you're seeking, it then automatically generates property orders. So really saving you time and maximising efficiencies. But moving on to just, Tim, if you want to go just to the list of documents that we can generate. There was just a question around what other documents do we generate. As you can see, there's the questionnaire, balance sheets in Word or Excel, proposals in Word or Excel, so you can send those to the other side, considerations, so contributions, future needs, disclosure indexes, disclosure letters, property orders, the draft financial statement, and that will be updated. The response form, we're about to launch that. A parenting plan, parenting orders, parenting consent orders, then heads of agreement, which a lot of mediators use. Draft application for consent orders for the Western Australian, although I don't know if we've got that many Western Australians because it's not irrelevant for the family court merger, but for those there, we've got some Western Australia specific forms, chronology, matter attachments, matter recommendations, etc. And we're continually updating this in line with the family court merger and really take a client focused approach to the roadmap. Some other questions, and then we'll move on to the next section. There was a question around and parenting, the availability to add, say, Christmas New Year, so Chinese New Year, and Greek Orthodox, Easter, etc. Yes, you can do all of that. You can remove the standard special occasions, and you can add whatever special occasions you want to add. There was another question around can you get the financial disclosure documents? Yes, if you get them from another platform such as your practice management system or other legal tech product, then you can upload those documents in a zip file, and we can take you through all this in a demo, but upload that in one go in a zip file, and it then downloads, separates those documents so that you can easily disclose them to the other side, and automatically generate those into a document index, etc. One last question coming back to the contravention. Somebody asked a question around the filing of the National Contravention List. Yes, all applications will be commenced via email, and you'll need an affidavit stating the facts, a copy of the order where required, a Section 60I certificate, unless an exception applies, and then it goes into details as to what you need in the affidavit, and that unlike the timeframes may be currently experienced, the contravention registrar will consider the application within 14 days of lodgement. Okay, I might move on to the next section, and there's a poll here in a moment that I'll bring up as well. Launch. So if you want to have a look at that poll, can you see that poll? Yeah. So there was a question that Jessica asked around dispute resolution and external versus court-based dispute resolution. As you would recall from the case management, there's a requirement for PreAction Procedures, family dispute resolution for parenting matters, genuine steps certificate, etc., before commencing court proceedings. But after commencing court proceedings, there's also a requirement for dispute resolution for both parenting and financial cases. Oh, sorry, I missed your slide there, Therese. Did you want to cover the first court event?
Yeah, I think I'll just stick to the first court event because the other things we have covered to some degree. Yeah. I really can't understate the importance of the first court event. It's a directions hearing before a judicial registrar, and unless there are exceptional circumstances, the court's going to be assessing the type of dispute resolution that parties will attend, and they'll make directions to get a matter ready for either an external or an internal dispute resolution. It's at that stage as well that they'll be checking for compliance with pre-action procedure, genuine attempts, and whether all documents are filed. They would expect from the parties that the significant issues have been identified and what evidence is required to move the matter forward so that they can make orders and directions to facilitate that. They will also triage the matter, including for risk, complexity, and urgency, and they may urgently transfer a matter to a judge or a senior judicial registrar on the day. In relation to parenting, they'll be looking at whether or not an ICL needs to be appointed or whether an expert report is required. And in relation to property, whether exchange of documents has occurred, whether there's a single expert report required, and whether the parties will agree to attend arbitration, which I think is interesting because it's something that I think from my memory has never been called out to such a significant extent. And yes, I think just in terms of the interim hearing, the map or the current pathway shows that it would occur before a dispute resolution, but I think it would be listed at the appropriate time, depending on what evidence is required and the issues that are, seeking resolution. Thanks, Fiona.
Thank you. So as we said, the first court event is really important, and that will be a triage on whether they should go to Division 2, from Division 2 to Division 1, but also the dispute resolution process that they may be referred to. So part of the first court event, and the next step will be that within 5 months of filing, there'll be a further dispute resolution event. And that there'll obviously be a consideration as to whether dispute resolution is appropriate in light of family violence and safety concerns. Remember, the core principle is always assessing risk. If it is suitable, there'll be an assessment of the means and resources of the parties will be considered on whether privately funded dispute resolution or it's court-based dispute resolution. And as Therese said, there's a statement that needs to be provided if there's no financial statement filed in the proceedings as to their income and expenses and ability to fund private dispute resolution and expert reports, etc. So that will be considered. And unlike at the moment, there's conciliation conferences or private mediation for financial matters, there'll, I think, be a distinguishment between if parties can afford privately funded dispute resolution, then they'll go down that pathway, versus court-based dispute resolution, and they'll do an assessment as to the means and resources of the parties and the appropriateness of the two options. For external dispute resolution, we've got private mediation, private legal aid facilitated, private FDR, legal aid facilitated or community-based FDR, and or arbitration with the consent of the parties. Whereas court-based, we've got the conciliation conference for financial matters, judicial settlement conferences. So that is given more prominence in the case in the practice direction, and FDR conferences, which has been introduced recently, where judicial registrars and sometimes the court child expert, or what was known as the family consultant, will perform a family dispute resolution conference, court-based dispute resolution conference for parenting matters, with 2 phases: part 1 to do an assessment, and then part 2, the more standard FDR joint session. So there's those various options, and in all cases, parties are to engage in good faith negotiations and make a genuine effort to resolve or limit or reduce the areas of dispute, and all agreements are to be recorded in writing. And I think there's an encouragement of reducing or limiting those issues, and if you can reach a partial agreement, then the outstanding issues can be determined by the court. And in appropriate cases, the parties are to consider arbitration. So again, arbitration and dispute resolution options will be considered at this stage. I think I put a poll up. Has everyone still got that poll? Yes, good. So just looking at the poll, I'll share the results of that. 67% said they asked for a case outline, 46% asked for court documents, 43%, so less than half asked for a cost notice or provided cost notice, 57% draft minute of order, 80% relevant documents, valuations, expert reports, and 70% provision of current and previous family violence orders. So it's interesting, if we look at the central practice directions and dispute resolution in the court phase, there's going to be, for private mediation, it's very similar for court-based mediation, dispute resolution, you need to provide all relevant court documents, any relevant expert reports, any document directly relevant to an issue remaining in dispute with relevant passages highlighted of those documents, a minute of order, a confidential case outline in an approved form. So there'll be, we assume there'll be a standard form for a case outline and a confidential case outline for mediation purposes. For a financial case, there'll be financial resources, evaluation or market appraisal of any real estate or other asset where the value is in dispute, most recent super statement, and procedural fairness about the super split. Current or previous family violence orders, which most of you do get, and then there'll be a new certificate of dispute resolution in an approved form. So we're not, we haven't seen that yet, but I'm assuming it's going to be similar to, say, the Section 60I certificate that will be completed for both parenting and property, confirming that the parties have participated and complied with these directions, etc. So that will be completed by the mediator, FDRP, and lodged by the applicant. So interested to hear your thoughts around that and referral out to either external dispute resolution or internal, and the preparation required for that. So I'll look at your questions, but in the meantime, Tim's going to briefly show you a case outline. What we're intending to do is, once we know the approved form, change the case outline so that it's in line with the new approved confidential case outline. But Tim will show you how that works.
Yep. Thank you, Fiona. Just getting my screen share up. Just can you see that okay? Yes. Fiona, can you see that okay?
Yes, yes.
Fantastic. Yeah, so that was a really good poll, and it's a really good to get an understanding of the kind of information that is required for dispute resolution, and there's a lot there. The good news is, obviously, with something like family property, we've already seen how it can draft, orders, proposed orders. So you can use family property to prepare for your dispute resolution session by generating orders. You can also upload all of those documentation, whether it's AVO documentation through to valuations and specialist reports, into the disclosure section in family property. And then you can simply just share a secure link with the mediator prior to the event so that they can have digital access to all of the documentation. So that was also in the poll reflected very favorably there at 80% need or require or provide the provision of those documents. So you can use family property to get them to the mediator or to the court prior to the event. But the third point is that case outline document. And so again, we've already got all the information in our balance sheet here, and we've already modeled out, I guess the position or maybe the agreement or the expectation here in our balance sheet. And so what you can do now, if you want to generate a case outline document, is you can head over to our smart form library by clicking on more and going to smart forms. And you'll notice here that we've got some fit for purpose built smart forms that you can use for specific reasons. And as you can see right up the top here, case outline is the top one. And so if you click on case outline, you'll see there's a bunch of questions that you can complete here: date of cohabitation, date of separation. And it just gets you to confirm the essential information that you would need and want to put into a case outline document. Obviously, all the information I've already got in family property is already just pre-populated in the smart form, so I don't need to spend time putting in extra information. We can see here information around the children is going to be collected and compiled into this document, as is information on the balance sheet. Already there, so I don't need to do any more work there. Liabilities, superannuation funds. I could also add any financial resources that I need to as well. And then finally, you can provide some information around considerations. So things like contributions and future needs adjustments, and then make a commentary on any facts that might be relied on around those contributions and future needs adjustments, and then any commentary that you might want to provide around your party's proposal. So you can fill this in this smart form here on the screen, and then simply click download to convert all of this information into a Microsoft Word document. One moment. Let me just reload that. Sorry, everybody is trying to do Zoom sessions in my area by the looks of it. Okay, let's try that one more time. Download.
And just with this case outline, you can also, with all of our smart forms, you can share a link with your client to complete that in draft before you settle it as, say, the lawyer in preparation for the mediation. Tim?
Yep. So here's the document. It's a Microsoft Word document. With everything in family property, it's all template driven. So we will update these templates as needed and as required by the courts. As things change, there's nothing you'll need to do. You'll automatically see an update in the template next time you generate it. But as you can see here, the balance sheet is fully populated with all the information there. And if I had filled in that last step in the smart form around considerations, that would also be populated. So this is a great case outline document that gets generated for you so that you can then really be well prepared for those conferences and mediations. Thank
you, Tim. And we might just clarify a few of the questions. One was, is the dispute resolution preparation, just to clarify, that is the second dispute. Once the matter commences court proceedings, this is the dispute resolution phase and the preparation that is mandatory for matters that are referred out from to external mediators, FDRPs, not prior to the commencement of court proceedings. A couple of other questions there. I might just hand over to you, Therese, to talk about the trial phase of the case management while I look at those other questions.
Thanks, Fiona. Okay, so in relation to the fast track hearing list, this is a list where matters might be put into it if parties have made a genuine effort and the issues remaining to be resolved are either limited or very discrete in nature. There's also a number of other requirements, such as that the expert reports have been obtained, that parties can agree that that the matter can be dealt with on the basis of affidavit evidence only, on written submissions no more than 10 pages long, and that they're ready to for the matter to be heard on 28 days notice. And lastly, that the parties consent to a short form judgment. In relation to the compliance and readiness hearing, this is obviously a very important date. It will occur following FDR and around 6 months after filing, or as close as possible. You'll see that there's a list of documents that would be required to be filed. I think the most important being that I'll speak about is the undertaking as to disclosure and also a certificate of readiness. So the certificate of readiness requires certain information, including compliance with orders and directions, that all valuations, inquiries, and expert reports have been completed, confirming that the matter is listed for final hearing, and if not, why not? And if the contents are not found to be accurate, the court might grant leave to the complying party or parties to proceed on an undefended basis. So we're going back to that emphasis on compliance. So in relation to the compliance and readiness hearing, parties will need to advise the court on similar things that we do now, which is the estimated length of final hearing, the remaining issues in dispute, and the legal and factual contentions in relation to those issues, who we propose as witnesses, whether interpreters are required, if video facilities are also required, and whether the expert evidence should be given via video link. And lastly, but very importantly, parties and their lawyer are also expected to make a genuine effort to agree on a trial plan. If we move on to the trial management hearing, this is a optional directions hearing before a trial judge, and that's really only going to occur if a judge thinks that this is necessary. And it's expected that the legal representative who appears at this hearing will appear at the final hearing, or the solicitor with conduct of the matter will appear at the final hearing. Okay. In relation to the final hearing itself, they are aiming to be listed within 12 months from the date of filing. And this might be subject to the parties complying with relevant orders and directions. In relation to if expert evidence is required by a court child expert, they need to be provided with 14 days notice, and also advised immediately if they're no longer required. So in relation to unreached matters, the matters might be listed for a dispute resolution on the day that the final hearing was listed. And it may be heard, or alternatively, it might be heard electronically by a judge in a different registry. And if it can't be resolved or heard on the day that it was listed, the matter will be referred to the National Assessment Team for relisting. I think just a couple of smaller items. With the circuits, the court acknowledges that it's not always going to be strictly possible to follow the standard case management pathway for these types of matters. In relation to specialist lists, that central practice direction that we've been talking about can be varied by the specific practice directions in relation to these specialist lists. And lastly, the central practice direction at the back of the document has the standard trial directions. And this includes things like what is required to be filed and served. Most importantly, parties will be only allowed to rely on one consolidated trial affidavit and one affidavit in reply, and all documents must be filed or provided in electronic format. They also need to provide a case outline in an approved form, and this must include the list of the documents that you want to rely on, a brief chronology that's specific to the issues that are outstanding to be determined. In relation to parenting, needs to have a summary of argument or contentions regarding the Section 60C factors that are to be relied upon. And in relation to property, there must be a table of all assets and liabilities and an indication of where values are in dispute, what contributions are claimed, the relevant Section 75(2) factors, and any other just and equitable factors. Thank you, Fiona.
Thanks, Therese. So what I'm hearing is that compliance is going to be a big factor, those compliance and readiness hearings and a certificate of readiness, and really with the aim to have the matter, I think they're aiming to have 90% of matters resolved within 12 months.
That's right.
So big aim, but hopefully with a focus on dispute resolution and focus on compliance, that will become achievable. So I'm just going to launch another poll. So just wanted to highlight, the Chief Justice said that one of the aims of the family court merger is to maximise efficiencies through the use of technology. I just wanted to highlight with Family Property, we aim to automate the admin, freeing you up to focus on your family lawyer work and family mediation work. We assist with intake, as Tim has showcased, that intake questionnaire around the general information, financial parenting and screening. We assist with collecting the documents and disclosure of the documents. And then we've got a dashboard for Party A, Party B, as well as a neutral dashboard where you're conducting, say, mediations or arbitrations. We really have tried to have a visual aid and quite a unique parenting calendar to visually help model what the parenting arrangements look like, that interactive balance sheet with the sliders to model out what's 50-50, 60-40, and save those various proposals and easily compare them, and then automate the documents. So everything from the balance sheets to proposals to the court documents. We're continuing to build those out. So efficiencies, I think particularly in these COVID times, it's really important to be looking at how your firm can maximise the technologies to make you more efficient. There'll be a big focus on reduction of costs and making sure things are efficient from a cost perspective. So thank you for filling the survey. I'll just share the results there. So about a third of you are using Family Property. Great to hear. Would love to increase that percentage though. So please feel free to reach out. I'll share that. For a demo, we'd love to showcase how Family Property can assist your firm. Video technology, I think with COVID, we're all becoming familiar with Zoom and Microsoft Teams, etc. E-signatures, we use one, it's great. Practice management systems, what are you using? How is that bringing about practice efficiencies? Remarkable or equivalent e-notebook, I find those great, and other legal tech platforms. So do reach out for assistance there. Last couple of things, we've gathered this information from the various sources. So the media releases from the court every Friday, they're coming out at the moment, as well as the National Contravention List Practice Direction and Form. We attended the Family Court webinar, and over its notes on that were then published in the Walters Kluwer article. So take a look at that. Couple of last poll here. Next steps, I'll launch that. So what we'd recommend is next steps. Book a demo of Family Property. Chanel, I think she's still on the chat. She's our business development manager, family lawyer. Happy to, if you click on that link, happy to do a free private demo of Family Property for your firm. For those that haven't already, if you can subscribe to, I'd recommend you subscribe to the Family Court updates, because then you'll automatically receive those other 13 practice directions, form updates, and latest news and media releases. So click on that. One of our Family Property subscribers, Jackie Bilson of Bilson Law, has offered to run a discussion group, peer support session every Thursday, 8:30 till 9:30 via Zoom. It's an open group, so feel free to join that group. I'll be attending there as well. And then there's a Family Law Pathways Network event on the 15th, I think it is, with Lisa O'Neill, Senior Registrar and National Registrar, Anna Parker, Senior Registrar and National Operations Registrar, and Janet Carmichael, currently Child Dispute Services, on the 15th of September. So I recommend you have a look at those. And I think poll results, great to hear a few of you are considering implementation of family property, court forms and rules you'd like to get a hold of, webinars to further discuss, and discussion group. So last poll. Any last questions before we finish? And I'd like to just find out if after the webinar, how helpful you've found it in starting to understand the changes. I'll just let you fill that in. There's some last questions here around professional legal costs. I think that will be in the rules as well. It will be the same sort of obligations to provide information around costs. We don't anticipate there's going to be changes to the court portal, but that's to come. And conciliation conferences are run by the registrars, judicial settlement conferences by the judges of the court. I think that's all of the questions. And great to hear that 90% of you have found, because I think it was the opposite way before, completely unprepared, whereas now starting to understand the changes, and a greater proportion feel completely on top of the changes. So that's great to hear. I think, Therese, did you want to finish? Any last comments?
No, I just wanted to say thank you to everybody who has attended.
And Tim?
Yeah, thanks very much for your time. Look, we love running these sessions. So please give us any feedback around things that you might want to see in the future, any other topics that you might want us to cover. If you're interested in more of a tech deep dive, we run those too. So yeah, please give us feedback on today, and we will look at running more sessions like this in the future.
Great. And there will be a final survey. I'm just getting my head around how to do these polls and surveys when you click out of the webinar. So please fill that in, and there'll be an automated follow-up email. And do stay in touch. We're hoping to run these again, perhaps more specialist family law discussions, but also, as Tim said, would love to showcase how family property can assist your family law practice. So I think that, and the slides will be made available to you with all of the relevant links, as well as the recording, because I know we had a number of people register for this webinar who couldn't attend. So for those watching the recording, hello to you all, and I hope that you have also found this helpful. Thank you. I'll end the session on Facebook Live, and I'll end the session on Zoom. Thank you.